Honorable Justice Indu Malhotra, Judge Supreme Court of India, Honorable Justice Pradeep Nandrajog, Chief Justice Bombay High Court, esteemed colleagues from the legal fraternity, and my dear friends, I am Alipak Banerjee and I work with Nishit Desai Associates. I am also a part of Young MCIA Steering Committee. On behalf of MCIA, we extend a warm welcome to all the speakers and delegates at the 4th Annual Conference of MCIA. We are privileged to have each one of you with us today. I, along with Mumtaz Bhalla from L&N Partners, New Delhi, will be a host for today's conference, where we will be discussing arbitration in India, blazing new trails or taking 2 steps back. I now request Honorable Justice Malhotra and Honorable Justice Nandrajog to come on the stage for the plenary session. I now request Madhukeshwar Desai, CEO MCIA, to address the gathering, please.
These lights in the eye direct create huge problems.
Respected Justice Indu Malhotra, Judge Supreme Court of India, Chief Justice of the Bombay High Court, respected Justice Pradeep Nandrajog, honorable members of the MCI Council, my dear friends. When we first conceptualized the idea to set up a world-class arbitral institution in India, we got a lot of advice. We got some good advice, some bad advice, and honestly some useless advice as well. But the one piece of advice, rather more of a cautioning, that we got from pretty much everyone that we spoke to, right from the good and the great to just well-wishers, was this: the most difficult task you'll have is surviving the first 1,000 days. Most organizations don't make it past their 3rd birthday. And that's why I'm very happy here to stand before you and celebrate our 1065th day of existence. We set out with a specific task: to bring international best practices to arbitration in India and to build an institution that is world-class, credible, transparent, and cost-effective. And it gives me tremendous satisfaction to say that we have stuck to those principles. In order for an arbitral institution to succeed, what is important is that it enjoys the support of the government, the judiciary, the support from the legal community, and the support from the business community. Lack of support from any one of these would make any arbitral institution limp. Over the last 3 years, we've worked very hard to ensure that we build enough legitimacy by getting the support of all the stakeholders. The government of Maharashtra took the lead. The government of Maharashtra passed an order mandating mandatory institutional arbitration for all government contracts over 5 crore rupees. The MCIA is now recognized under this government order, and you now see government contracts with MCIA clauses as standard. The latest addition to this is the BMC, the richest municipal body in the entire country. In fact, its budget would rival some state governments' budgets as well. This body now has MCI clauses as standard. It has also urged private parties that have entered into agreements with them, that have arbitrations that are about to commence, to move to MCIA. In 2017, the Supreme Court asked MCIA to act as an appointing authority in a Section 11 matter. Not to be outdone, the Bombay High Court the following year in a Section 11 matter appointed an arbitrator but converted an ad hoc arbitration to an MCI-administered arbitration. While this is a huge demonstration of faith by the courts in the MCIA, to my mind what is important is the message that this sent out to the global arbitration community. That institutional arbitration had the support of the judiciary in India. If you stand at the MCI headquarters at the Express Towers here in Mumbai, and you draw a 5-kilometer radius, you'll find some of the richest, largest, most powerful corporates that are headquartered here in India, but are global and outward looking. A large number of these corporates now use MCIA as a standard clause. I'm going to take the liberty of dropping a few names here. The Mahindra & Mahindra group now use MCIA as a standard clause across their entire group. If you check into a Taj property anywhere in the world, you're entering into an agreement with an MCIA clause. Metro Cash and Carry, the Volkswagen Group, Philips Lighting, there are a whole host of companies that now use MCIA as a standard clause across all their contracts. But it's not just Mumbai. Corporates in Delhi, Mumbai, Gujarat, Bangalore now use MCIA as a standard clause in their companies. We received overwhelming support from law firms, lawyers, and the legal community. Be it in the form of sponsorships, supporting our events, speaking to young lawyers when we organize training programs, and supporting our global outreach. The legal community has really come together to make sure that the MCIA succeeds. The Bombay and Delhi Bar, which didn't just stop at organizing events for us, have truly supported the cause for institutional arbitration. Some of you I won't name are always just a phone call away every time we have a doubt, a question, a query, or need guidance with anything that we need. And I must admit that we wouldn't have reached 100 Ds, leave alone 1,000, if it wasn't the support of the legal community. The most common question that Neeti and I get asked right from the beginning was, how many cases have you administered under the MCIA rules? This is nothing short of asking a fresher the number of years of experience she has. But today I'd like to share some numbers with you. 5 is the total number of cases that the MCIA has administered, out of which 3 have contracting parties that are from jurisdictions outside Mumbai, and we have administered 1 international arbitration. But without divulging the details of the case, I'd like to touch upon one that gave me, Neeti, and the MCIA Council tremendous amount of joy. A case came to dispute with a contract that had an MCIA clause in it, an organic clause. This told us that people weren't just telling us that they're putting in MCIA clauses, but they were actually putting in and contracting MCIA clauses. In an apples-to-apples comparison, I can confidently say that there's almost no arbitral institution of worth that can say that they have administered 5 cases in the first 3 years of their existence. While we're on numbers, I'd like to share one more. 600. 600 and counting. The number of times our rooms have been used at the MCI premises. We were the first hearing facility in India to offer breakout rooms, soundproof hearing rooms, complete automation, and an arbitrator's lounge. While there's a significant uptake in domestic arbitrations, we now see more international arbitrations being conducted at the MCIA premises as well. As a proud Indian institution, we find it our responsibility to not just speak about the MCIA, but also about the progress that India has made as a center for dispute resolution. We do this by conducting roadshows across India as well as international jurisdictions. I'm happy to report that we have done it. We're conducting roadshows in over 6 international jurisdictions, and we've received positive responses from all of them. In fact, we have 4 more roadshows this year, and Neeti will speak a little bit about the coming roadshows that we have in the following year. India is synonymous with young. And with the growth of the young MCIA, I think MCIA will be synonymous with young pretty soon as well. The young MCIA now has over 700 members, a new steering committee with over 19 new committee members representing 9 jurisdictions. The young MCIA has been working hard to organize events and training programs to build a strong arbitration community. In fact, I'd like to congratulate them for an event well organized yesterday, an event organized for 60 people where 120 turned up. While we are extremely happy that we've survived the first 1,000 days, The point of the MCIA is not for us to survive 1,000 days. The point for us is to thrive over the next 10,000. And I'm confident that with your continued support, we'll reach there. Thank you so much.
Thank you, Madhukeshwar. May I now invite Justice Malhotra, our chief guest, to deliver her address, please.
Honorable Mr. Justice Pradeep Nandrajog, Chief Justice, Bombay High Court, Mr. Madhukeshwar, CEO, MCIA, Ms. Neeti Sachdeva, Registrar of MCIA, distinguished arbitration practitioners from various jurisdictions, members of the legal fraternity, my warm greetings to all of you this morning. I am honored to be invited as the chief guest for the MCIA's 4th annual conference on arbitration in India, blazing new trails or taking 2 steps back. I am happy to note that institutional centers such as the MCIA has played an active role in streamlining commercial dispute resolution and providing world-class arbitration rules to administer arbitration. In fact, just within 1.5 years of its establishment, the Supreme Court had referred an international commercial dispute for arbitration to the MCIA, which has been successfully completed. The award has been passed. Now that apart, what I intend to speak today, the focus is going to be with respect to the 2015 amendments, and I was a member of the high-level committee, so I will certainly have some amount of bias, which I do want to tell you right at the outset, because that was the basis of the 2019 Amendment Act. And I am going to share with you what was the basis for some of these amendments. There is a lot of apprehension which has surfaced, particularly with arbitration practitioners. We are cognizant of it, and I will, in that background, share with you what was the background in which we made certain recommendations which have been translated into the 2019 Amendment Act, of course, with modifications. It has not been followed in entirety. India has been striving to be a jurisdiction for the better enforcement of contracts and ease of doing business. Post the 2015 Amendment Act, India has climbed up to position number 77 from 100 by the World Bank ratings. The target, of course, for enforcement of contracts, we are still rated pretty low at about 163. The target of the government is to reach rank 30 by 2030. Now, to achieve that purpose, first the 2015 Amendment Act came in, which was after almost 20 years, after the 1996 Act had come into force. There were various issues which emerged, and I'll just broadly touch upon the amendments. The first amendment is to streamline arbitral proceedings with respect to the time spent by the arbitrators in concluding the proceedings. As all of you know, the bulk of arbitrations was conducted by ad hoc tribunals, which were completely unregulated, whether it was with respect to the time taken or with respect to the fees charged. Arbitral proceedings were pending for years and years before they would come to a conclusion. So the first thing which was addressed was to provide a statutory time limit for conclusion of proceedings by the introduction of Section 29 A. The second contribution was that fast-track arbitration was introduced into the Parent Act, which was not there earlier. The third was the Section 11 power of appointment. As all of you are aware, that there was a lot of controversy which emerged from two constitution bench judgments. The first was Konkan Railways, which described the power of appointment which had been bestowed on the Chief Justice of the High Court with respect to arbitrations in India and the Chief Justice of India with respect to international commercial arbitrations. Now, the view which was taken initially in Konkan Railways was that it's an administrative power and you appoint and don't do anything beyond that. And then came the Patel Engineering by a 7-judge constitution bench. In fact, I had appeared also before that bench, where the court enlarged the scope of scrutiny at the threshold pre-reference stage. The issues whether a claim is a dead claim or a live claim, whether there was accord and satisfaction, whether the dispute was arbitrable, the 7-judge constitution bench held that these are threshold issues, and why should a party be dragged through a long-drawn arbitration which is costly and expensive? Why should these issues not be resolved by the court? But the consequence of this judgment was that it totally undermined the competence principle. The courts undertook the scrutiny at the pre-reference stage. They termed it as a judicial power. They said that this power cannot be delegated to any person or institution. It has to be exercised by the court. The decision, so as a consequence, the 2015 Amendment Act was brought in, and the power now under the Act was shifted from the persona designator, that's the Chief Justice, to the court. It was the High Court for domestic and Chief Justice of India for international. It was also clarified that this power could be delegated to a person or institution, and that would not amount to a delegation of judicial power. The decision passed under Section 11 would be final and would not be subject to any further review. And finally, there was subsection 6A, which was introduced by the 2015 amendment. And I want to specifically mention it because this provision has now been deleted by the 2019 Amendment Act. Subsection 6A in Section 11 said that the scope of scrutiny at the time of reference by the court under Section 11 will be confined only to the existence of the arbitration agreement and no further. It was obviously brought in to overcome the effect of the 7-judge constitution bench in Patel Engineering and a host of other decisions like Bogara Polyfab, Master Construction, and various other decisions of the court. The next aspect which the 2015 Amendment Act addressed was on the issue of conflict of interest of arbitrators. And this issue, which I personally also felt very strongly about, and I've commented very strongly in the 3rd edition of my commentary, is that primarily in government contracts and contracts with PSUs, it was always a named arbitrator, a person who was an employee of that public sector or of the state government. The only caveat was that such a person should not have dealt with the contract. And I don't think that was a sufficient safeguard. There is institutional bias. When you go to an arbitrator, you expect complete neutrality because you don't have another innings. The objections you file are very limited and are viewed narrowly. So therefore, your only innings has to be a realistic and a fair one. So the 2015 amendment brought about various amendments in Section 12, calling upon arbitrators to file a statutory declaration about conflict of interest, time availability, and it also gave, interestingly, statutory force to IBA guidelines, which are treated as soft law in foreign jurisdictions, but India introduced Schedule 5, but Schedule 5 is of guidance. It is not it's not binding or mandatory, but Schedule 7 has been given statutory force when read with Section 12.5, saying that certain degrees of relationships are per se ineligible to be appointed as arbitrators. So this was one of the greatest contributions, and this entire procedure of government contracts, PSUs, saying that it will be only their employee doesn't hold good any longer. In fact, I remember coming across a lot of contracts of the largest PSUs saying you will exactly, it was written that you will sign on the dotted line, not a change in the full stop or comma of the contract. So there was actually unequal bargaining power. The other important, significant contribution which has been brought about by the 2015 Amendment Act was to empower arbitral tribunals to provide interim relief. But when that was done, there was an error made in the Act. And the error was that they took the entire Section 9 and put it verbatim in Section 17. Now, the error was that an arbitrator can provide interim relief only during the subsistence of the proceedings. The minute the award is passed, the arbitrator becomes functus officio. He has no jurisdiction, he cannot pass any interim orders. So they had just copy-pasted Section 9 into Section 17, but in any event, empowering the arbitrators and the tribunal to provide interim relief was a significant step forward to obviate the necessity to approach courts for interim relief during subsistence of proceedings. Another important amendment was, it was more clarificatory in nature, which was in Section 34, which stated, an explanation was inserted, which clarified that an award will not be set aside by the court merely on an erroneous application of the law or a reappreciation of the evidence. The court, under Section 34, will not review the merits of the dispute in deciding whether the award is in contravention with the fundamental policy of India. Lastly, and I think it is the most important amendment, which came in Section 36 of the 96 Act, on an interpretation of the Parent Act. In two decisions, that's National Aluminium and Afcons, the court said that once objections are filed, there is an automatic suspension of the award. Now, this resulted, it was a very convenient way for a party which had lost in the arbitral proceedings to file objections at the earliest and get the entire proceedings stalled. And this went on for very often almost a decade. The entire arbitrator would be hanging fire, and in the meanwhile, the party which lost would just siphon away its assets, and it would become a paperless remedy. So Section 36 was substituted almost in entirety, saying that there would not be any automatic suspension. You would have to go to the court, and if the court granted a stay, there was an obligation to provide reasons for an order of stay. And there are various other amendments, I'm just broadly touching upon it. On 23rd October 2015, the 2015 Amendment Act had come into force. And just a year over, on 13th January 2017, the Ministry of Law and Justice set up a high-level committee which was presided by Justice Sri Krishna. I was a member of that committee. We had 2 retired Supreme Court judges, a sitting judge of the Delhi High Court, and there were various solicitors' firms who were representing, there were various arbitral institutions which came and represented. I will now touch upon the 2019 amendments and give you the backdrop of it. I will of course not make a comment on the amendments because they may be the subject matter of challenge before the courts. So I will touch upon it, giving you the backdrop. The first point which I want to comment upon and which has emerged to be the most controversial, which arbitration practitioners have found most troublesome, is the constitution of the Arbitration Council of India. Now this body, I want to tell you at the outset what the high-level committee did, and I think the Act has not deviated too much from there. It is not a regulator. There is no role of regulating any institution which has been ascribed to it. That apprehension, I think, is unfounded. This body has been set up. One is to provide accreditation to arbitrators and also to do a kind of a grading of arbitration institutions which are functioning in India. When I was a member of the high-level committee, we had extensive research done, and we found 35 institutions which were operating in various parts of the country, and we tried to make an assessment of the way they were functioning. So on that basis, we thought it would be a good idea to have an institution which provides for accreditation of arbitrators, because I genuinely feel, even as judges of the High Court, Supreme Court, after retirement, when we act as arbitrators, I think we need a specialized training. Very often, there are arbitration practitioners who say that your arbitrators sit in seclusion, they don't interact. It's important when you resolve commercial disputes, you have to take off the mantle and the cloak of being a judge of a court having constitutional powers. Your powers as an arbitrator emanate from the contract. These are commercial disputes, they have to be dealt with commercially. So we wanted training to be conducted of arbitrators, of practitioners in our country, for which this institute was to be set up. They would make recommendations to the government. They would hold training, workshops, and courses. Now, the object of grading institutions was because the 2019 amendment made the concerted effort to move away from ad hoc arbitration to institutional arbitrations. Ad hoc arbitrations were completely unregulated, and that is why the pitfalls came in on no regulation on time, no regulation on fees, and it was carried on in a lackadaisical manner. So we thought it was the best way to bring about, to strengthen institutions, and the reason for grading them was because if you read Section 11, which is the most important amendment which has been introduced by this Act, the object was to move the power away from the court, and the court designates an arbitral institution, just as it's been done in Singapore and Hong Kong, to make the appointment and conduct the proceedings. There is no regulatory role which has been ascribed to it. If you're graded low, so be it. It doesn't have any consequences. Another aspect which has been adversely commented upon is about the depository of arbitral awards. I'll tell you the background to it. The background to this is, as you are aware, that the bulk of arbitrations in India were being conducted by ad hoc tribunals. Once the proceedings were over, the award was passed, what would the arbitrator do with the record? Whom would he send it to? And the courts very often found that they did not have an authenticated copy of the award. So they would insist with parties that you take it back. We have no storage capacity to keep your awards, and when the matter goes to court, you make provision. So there were senior arbitrators, retired judges of the Supreme Court and the High Courts, who said, why don't you create a centralized depository? Space is an issue, keep it in electronic form. That was the background in which this depository, the provision to create a centralized depository was created. It really, the aspect of confidentiality really did not enter, because once the award is passed and it goes to court, it comes into the public domain. So the confidentiality of the award really wasn't a concern at that time. It was only the awards which would be electronically maintained. So as a consequence, Section 11 is the most important section which has been revamped substantially and significantly, and the main subsection which I will mention is subsection 3A in Section 11, which provides that the Supreme Court and the High Court shall have the power to designate arbitral institutions from time to time which have been graded by the Arbitration Council of India. So this grading is a form of accreditation so that the court would be able to refer matters to these institutions to make the appointment and conduct the proceedings. In fact, the example I gave you when the bench of Justice Adarsh Goyal and Justice Lalit had referred a matter to MCIA, they refused to appoint the arbitrator. They said, go to this institution, it's functioning very well, we are told, so let them do it from start to end. So that, and a lot of foreign arbitration practitioners had this misgiving. They said, your country doesn't have any centralized institution. So with that view in mind, and to divest the court of the power, it was decided to revamp Section 11 substantially, to let the power pass on to the institutions, and the court would not really play any role in that. They would just refer it directly to an institution which of credibility. So subsection 6A, which had confined the scrutiny to the existence of an arbitration agreement, has been deleted. Subsection 7 of Section 11 has been deleted, because that said that an order passed by the court would be final. So all these subsections have been deleted, and consequential amendments have been effected in the remaining subsections, which I will not read to you. Insofar as 29 capital A is concerned, several arbitrators came and represented, and solicitor firms, saying it becomes very hard for us to complete the arbitral proceedings within a period of 12 months. They say, please do it post pleadings. So therefore, an amendment has been effected in 29A that after the SOC is filed, SOD is filed, within a period of 6 months, the 12 months period starts ticking. Insofar as international is concerned, they have kept them out of it, because most of the foreign arbitral institutions said, we conduct and monitor our proceedings, there is no complaint of delay, so please keep us out of it. We are conducting the proceedings. So for that reason, this provision was made inapplicable to international commercial arbitrations. There were two clauses which have been newly inserted. One is with respect to confidentiality, and the other was immunity of arbitrators. In fact, a very senior retired judge of the Supreme Court complained that after he passed the award in an international commercial arbitration, he received a notice from one of the parties saying, I'm going to take you to the cleaners for having passed this award against me. He said, I think it's high time that we require some protection which is provided by all other arbitration statutes world over. There were certain clarificatory amendments which were introduced. One was Section 2.2 was amended because insofar as an appeal is concerned from 9 for an international commercial arbitration, the appellate provision was mentioned as 37(1)(a) in the 2015 Amendment Act. This has been rectified by the 2019 Amendment Act to say it's 37(1)(b). So that was one of the clarificatory amendments. There was another clarificatory amendment which we got introduced in Section 17, that the arbitrator cannot provide relief post the award. So that part was deleted from the provision. In Section 34, it begins by saying that a person who files objections will do so by making the application and furnish proof that. Now this was interpreted by some high courts to mean that it should be done by framing of issues and filing of affidavits by way of evidence. So there was, in fact, Justice Nariman and myself had passed a judgment in MK Global Financial Services. We said furnish proof means that you have to provide the evidence from the record of the arbitral tribunal and not anything else. There can't be leading of evidence. We clarified. The legislature has now given effect to it by clarifying that proof on the basis of the record of the arbitral tribunal is what furnishing proof implies. In Section 37, an important amendment has been brought about, in fact, in one of the judgments of the Supreme Court. They said that Section 13(1) of the Commercial Courts Act provides a general right of appeal, and that should now be available even in arbitration. So we had suggested that you must incorporate a non-obstante clause in Section 37 to clarify that notwithstanding anything contained in any other act or rules, it will be as per the Arbitration Conciliation Act of 96, which is a self-contained code, and that has been given effect by this amendment. The amendments have been made prospective. I will not comment on that. They have already been the subject matter of litigation in the BCCI case. I will leave it at that. Insofar as these 2019 amendments are concerned, most of them have been brought into force with effect from 30th August 2019, except Section 2CA, which says arbitral institution designated by the Supreme Court or High Court. That has not been notified, nor has Section 11, nor has Part 1A, which pertains to the setting up of the Arbitration Council of India, and the 8th schedule, which prescribes qualifications for Indian arbitrators under Part 1 of the Act, has also not been notified so far. In my view, the amendments brought about by the 2015 and 2019 Amendment Acts are certainly steps forward, and I think India is progressing in the right direction. Every legislation, every amendment has glitches. The setting up of this council has not taken place. It is at a nascent stage, and the government is taking a very proactive stand. They are coming out with swift amendments, and if there are imponderables, I'm sure they will be addressed. These are my thoughts on this subject. Thank you.
Thank you so much for such an insightful address. May I now invite Justice Nandrajog, our guest of honor, to deliver his address.
Sister Indu, the organizers of the event, members of the bar, It's indeed my honor and my pleasure to be here on a Saturday morning. Thank you for having given me this opportunity, and welcome and good morning to all of you. Sister Indu has pen-profiled the ethos of the amendments incorporated to the Arbitration and Conciliation Act 2015 and 2019. So really nothing much remains for me to re-speak and rehash on those issues. But since we are here to look at whether we are blazing new trails or taking 2 steps back, we really need to look at the growth of arbitration law in India, starting from before the 1940 Act, when arbitration was simply governed by the erstwhile Code of Civil Procedure. We had the 1940 Act, we had the 1996 Act. Somewhere I think the craving of the justices in India to do justice in terms of what they perceive to be right had led to huge issues. Get back to that famous Privy Council judgment of Chemsebara. It was a time when the society's faith in arbitrators was that even a non-reasoned award was acceptable to law, because one believed that he who sat on the seat of justice and adjudication would reach to just and fair conclusions, and he need not give reasons as to why he has reached that conclusion. And yet, we found judicial intervention. Theories and theories got evolved by courts. A document referred to in the award, does it get embedded in the award? And if it has got embedded in the award, would the interpretation of the document be revisited by the court? We went into issues of construction of a contract being a matter of law, interpretation of a document being a matter of fact. Interpretation would admit of parole evidence, construction would not admit of parole evidence. The whole thing became so extremely confusing. The legislature stepped in, and we had the 1940 Act, and we had only 2 sections of Section 30 and Section 33. So errors within jurisdiction, errors outside jurisdiction, whether in relation to the interpretation of the contract, if a fundamental principle of interpretation of the contract has been overlooked by the arbitrator, it would relate to an erroneous exercise of jurisdiction by the arbitrator. And then we started having cross-fertilization of principles of administrative law. You'll find large number of decisions dealing with arbitrations awards, transmutating principles of administrative law in terms of exercise of jurisdictions. It's easy to say that the new amendment says that reappreciation of evidence would not take place. The crafty lawyer would always say, so reappreciation, I'm not reappreciating the evidence at all. I'm actually arguing it's a case of no evidence. And then he would take the court through what? That unless 2 facts are proved, the inference drawn cannot be sustained, and the arbitration record is full of proof of fact 1. there is no fact to be proved and therefore the inference drawn is incorrect. Actually, that is the real area which the statute needed to rectify. If I was to make a graphic of the foras of resolutions of disputes which arise in society, I could conceive of Lord Krishna's chariot with 5 horses. At the central horse is the traditional courts. The 2 horses on the left would be the horses of mediations and conciliation. And the 2 horses on the right would be the tribunals. And by the tribunals, I would mean the statutory tribunals which are constituted, and also the arbitrators, because they are also akin to private tribunals constituted by consent of parties. And Lord Krishna's chariot was being pulled by the 5 horses, knowing fully well that as the chariot maneuvers on the curves, the horse on the inner side anchors, and the horse on the extreme right powers. So somewhere the belief was that out of these 5 horses, which would pull the chariot of dispute resolution for us, you would have a chariot of arbitration, a horse of arbitration, which would anchor and at the same time propel. But what happened was that the central horse, the horse of the court, would say that I would anchor and I would propel. And that's where the real issues arise. It would be interesting to see, as per me, what happens to the interpretation, to the amendment to Section 34. In fact, if you would see the mess which got created, and I would use the word mess because it took over a decade and a half for the courts to settle what Section 11 meant. And to me, it was very simple. If you look at your arbitration clauses, all of them say, "The all disputes touching upon, arising out of, and relating to my contract would be referred to an arbitration." So where was the question for anyone to delve into the issue in terms of whether the dispute subsists, whether there is accord and satisfaction? Even if the dispute related to whether there was an accord of satisfaction, it still arose out of the contract. It had to go to the arbitrator. In other words, that the scope of Section 11, as I think originally conceived of, is a dispute arising, and not to get into the nature of the dispute, whether it is a live and a kicking dispute, because then you enter into areas of adjudication, and Section 11 was not meant to be a fora of adjudication. I'm happy that the new Section 11 as amended removes that, but then lawyers are lawyers. They're crafty. So I'm waiting for a lawyer to get up and say, when you talk of an accord and satisfaction, and the principle of law is that if the satisfaction of the award is a resolution of the dispute, and I'm raising the question that yes, there is an accord, but there is no satisfaction of the accord, and the satisfaction itself would resolve the dispute, and hence the arbitration clause survives. And the other person would say, it is the accord itself which was the satisfaction of the dispute, and whether there is the satisfaction of the accord, it generates a dispute by itself. Why I say so? Because when I look at the past, these niches which got created, there has been no attempt actually made under the latest amendments itself. So when we say that reappreciation of evidence, earlier on also the court said that you will not reappreciate the evidence, but then it was hedged by reappreciation of the evidence to determine whether the conclusion arrived at is correct or not. We still have judgments which say that if relevant evidence has not been discussed, it would be an erroneous award. It's such a woolly phrase. Those of us who do trials. The toughest part of the law of evidence is the part 3 of the law of evidence, when the production and effect is discussed. We have now a judgment which talks in terms of that the task of the court is to see whether the award shows a judicious approach. When the judgment came, I said, let me pick up the dictionary, the thesaurus, and really find out what is a judicious approach. I was quite horrified when I read what was a judicious approach, and it said that it must be wise, sensible, prudent, well judged, well thought out, perspective, discerning, insightful, informed, intelligent, logical, and rational. So all these features would combine for an award to be considered from the point of view of judicious approach. And this is exactly what we see in the courts happening. Something or the other relating to a pleading, something or the other relating to the evidence, documentary or otherwise, having a feature of whether it is thought out, whether it is discerning. But I said, let me see the antonym of a judicious and what would be an injudicious approach. I was happy to note that it was only 2 words, foolish and ill-advised. So you just see that the placement of the onus on the award to be showing a judicious approach invites such a deep and penetrative intervention by the court. But if the onus would be to see whether the award is foolish or ill-advised, it would require the interventional power of the court to be reduced to the bare minimum. So it would be really interesting to see that are the justices ready and willing to accept that they are one out of the 5 horses pulling the chariot, and the role of the central horse is neither to navigate, nor to anchor, nor to propel the horse which is pulling the chariot in the domain of dispute resolution adjudications. And why I say so is that as a judge you get ingrained on principles flowing out of your civil procedure code of placement of onus, shifting of onus, and you keep on sieving through the evidence that the onus has shifted, this evidence repels and shifts the onus back, and we tend to indulge in those exercises. The statistical data is very interesting, and I don't know why has anyone not really brought it in public domain. Judicial intervention and appellate jurisdictions over decisions of trial courts is 5 out of 100. And the reason is that all of you would understand that 8 out of 10 cases have their own weight where you don't really have to scratch your brain too much to reason out. It is only 10 out of 100 where a little bit of exercise needs to be put to remove the haze which the plethora of facts create. And even those you would find, with a little bit of effort, resolve themselves on their own reasoning. And the reason is that the human brain is like a computer. So all you do is in the computer you put in some algorithms, which we call as the software. And the task of the computer operator is to feed in the relevant facts and press the button, and the algorithms work themselves out for the data analysis. Same thing really happens in a decision-making process. Your algorithms are your principles of law. All you have to do is put them in your head. With a little bit of effort, you have to push in the relevant facts, and the brain does the rest itself. So the question which really would arise when we would answer this question, blazing new trials or taking 2 steps back, that what kind of formality in the expressions and the process of reasonings which are coming in the award would stand judicial scrutiny? Would those principles of error within jurisdiction, principles of errors outside jurisdiction, principles in terms of that the arbitrator is the creature of the contract becomes his Bible, he must recite the Psalms from the Bible. If he recites the Psalms outside the Bible, he has not prayed well. As jargonistic phrases, they look very, very attractive. But as you start applying them, you'll have 10 judgments on one side, you'll have 15 on the other side. The 10 on the other side would say, well, it didn't fall for, the contract was so clear that the arbitrator was not supposed to reinterpret it. And the other side said the arbitrator hasn't reinterpreted it, he's interpreted it. And you say, oh, no, it didn't really arise. So is an arbitrator to write, this is the phrase which is coming up for consideration? Is he to write that I am picking up Wren and Martin? So this is the subject and this is the predicate. And this phrase arises out of the subject of the clause, and I'm concerned with the predicate of the clause. Surely this is not the task. But unfortunately, the case law has developed in those areas. And the problem with arbitration really doesn't lie much, I think, till the stage of rendition of awards. The problem comes, the process of subjecting that award to the scrutiny of the law, the process takes so long. In fact, if you would see, we have the reviews done, and we find that the intervention by courts in the awards is percentage-wise just the same as it is abroad. But it is only that we've made our processes of letting the award pass the test of judicial scrutiny little complex and little long. I would wait for the case law now to develop in terms of the amendments which have been made to 34. Others were procedural in their nature. They were not really at the core of the issues which were arising in terms of arbitration. It would be interesting to see whether the specialized arbitration bar and the arbitrators continue to follow the conventional methods of pleadings which we have got so used to in courts. Or do we go for something like pleadings in the form of memorials? Do we get over the mindset that when the Code of Civil Procedure was made in 1908, 99% of the disputes which were brought to the court had more than 90% of oral evidence? Commercial disputes have hardly any scope of oral evidence because everything is in writing. Even the so-called parole evidence is in the form of emails exchanged, it is in the form of letters written. Do we really require oral evidence to be led? Is a question which needs to be put. Do we focus on facts in dispute in terms of bench memorials placed? The lawyer who's filing the response to the claim, stating up and saying that I understand the claim raising these 4 issues and I deal with the 4 issues, and in rejoinder the person says, no, I did not raise 4, I raised 5, he's overlooked my 5th. Is it that precision which comes? That would be interesting, and I hope that you have some seminars, not in terms of what we've been discussing in terms of case laws, but in terms of new forms of pleadings to be brought about. I see today in pleadings that concepts of, is it a plea of demurrer coming, and the lawyer comes and says, sir, give me time for a replication. And you say, what replication would you file? It's just a plea of demurrer. So the written statement is just a plea of demurrer. The plaintiff has to prove everything, and you don't have. And we used to see it in the Delhi High Court. The replication were coming wrong and denied, reiterated, wrong and denied, reiterated endlessly. So when we talk in terms of that, do we take new trials or we take 2 steps back, it would all mean that we have to dissociate ourselves from the habits of the past which we have so ingrained in ourselves, we have to break through. If we break through that, surely we will blaze new trails, and if we don't, then probably the past will pull us, maybe not 2, but perhaps 3 steps back. I hope these issues are discussed at your sessions. Let them not be theoretical. Let them be practical. And please do take out a paper at the end of your deliberations and circulate it. Be critical of the system, because these are events intended to take a critical look at what went wrong. You're not meant to pat yourself on the back that we have done wonders. Because if you've done wonders, then society will not require you to have these seminars. They are intended to find out where we went wrong, where do we need to improve, and where do we need to take ourselves forward. I wish you all a success at your sessions and your deliberations, and God bless all of you.
Thank you, Justice Nandrajog, for your time and the address. We'll now break for tea and coffee. Let's assemble back at 11:30. Thank you. Yeah.
Morning, everybody. Honorable Justice Indu Malhotra, Honorable Justice Pradeep Nandrajog, thank you for accepting our invitation to be here and to extend your support to institutional arbitration and to MCIA. On behalf of MCIA and personally, I wish to thank you for your time today and for all the valuable suggestions that you have given us. Ma'am, your address on the backdrop of 2019 amendments and setting the stage is actually going to set the stage for the discussions and deliberations today. Sir, I assure you that the sessions as we have lined up and finally a debate on how the 2019 amendments are actually new blazing trails or taking 2 steps back will be critical enough, and we'll be very happy to circulate a paper after that. We, the younger generation of arbitration, as we call ourselves, are always happy to have the encouragement and the support of the arbitration community, bar, and especially the judiciary. We are thankful to all of you present here for making this conference a success. Madhukeshwar, in his opening remarks, did speak about some of the significant steps that we have taken, and he spoke about one of the cases which is close to his heart, my heart, and MCIA, and I would just like to add one more thing to that, is that the matter which came in from a contract had no real connection to Mumbai except being the MCIA. It was a party from Chandigarh and Jaipur contracting with a seat in Delhi and agreeing to have an MCIA dispute resolution institution. I think it speaks a lot of how we as a jurisdiction have matured and understood that an institution is not linked to its existence or presence, physical presence in a particular city or state. The progress we have made over the last 3 years is just the beginning. I assure you, we are committed to achieve a lot more and make institutional arbitration the way we arbitrate in India. All of this is not possible without your support. And in the coming years, we are all geared up to take MCIA to next steps, not only within India and do our events in Ahmedabad, Pune, Bangalore, Hyderabad, Chennai, and Vizag, but we've also been welcomed with open arms with the international community, and MCIA will see doing its road shows across Japan, South Korea, Dubai, Germany, Singapore, and Malaysia, to name a few. Ma'am, we do take your suggestions very seriously that training is an essential part if we have to grow as a jurisdiction and grow doing arbitration. MCIA, besides its endeavors to talk about roadshows and events, very closely looks at training programs. And the two kinds of training programs lined up for the next couple of years is training of arbitrators. As the cliche goes, your arbitration is only good as your arbitrators, and we take that very seriously, ma'am. The second is a training for our young lawyers. Teach them young, see them grow is the motto. We have Young MCIA. We have a lifeline of an arbitration, which is a 5-session series of how an arbitration runs right from your drafting to an award over the next 5 months. We will continue to spread awareness about MCIA, and we urge all of you to continue your support to MCIA, not only by incorporating MCIA clauses in your contracts, but by giving us your valuable suggestions, support as to how we can grow this institution, how we can grow institutional arbitration in India. Madhukeshwar and I are available anytime for any clarifications that you might have on our rules, on incorporation of clauses, or any endeavor that you can actively participate in. Last but not the least, we also have a video station booth which is set up in the adjacent room, and we'll be very glad for you to share your experiences of MCIA in the last 3 years or any comments that you might have. With that, I thank Justice Malhotra, Justice Nandrajog, and all of you present here for making it this morning and making this conference a success. Thank you very much.